The next part is parties of the deed. Besides the transferor and the transferee, the parties to the deed comprises every person whose consent is necessary to make a perfect deed of the property. In fact, who are proper or necessary parties to a deed depends upon the circumstances in each case. The details of the parties should be given in such a way which the parties can easily be identified. It is reasonable to describe the parties by their name, age, occupation, and residence. It is necessary for the draftsman to determine the parties who should be joined in his drafting. For this purpose, you should remember one of the most essential elements of a valid contract is the competency of the parties to make a contract as a natural person. And Section 11 of the Contract Act 1872 defines the capacity to contract of a person to be dependent on three aspects. Number one, attaining the age of majority, being of sound mind, and third one is not disqualified from entering into contract by any law that he is subject to. Therefore, the law indicates that we have three main aspects. Number one, attaining the age of majority. The age of majority in Bangladesh is defined as 18 years. For this purpose of entering into contract, even a day less than this age disqualifies the person from being a party to the contract. Any person domiciled in Bangladesh who has not attained the age of 18 years is termed as a minor and not competent to enter into the contract. Though there is an exception. That is, minor can be a beneficiary of a contract, while a minor cannot enter a contract, but he can be the beneficiary of one. The Partnership Act 1932 also specifies that while a minor cannot become a partner in the partnership firm, the benefits of the firm can be extended to him. Another one is contract by guardian. Under certain circumstances, a guardian of a minor can enter into a valid contract on behalf of the minor. Such a contract, which the guardian enters into for the benefit of the minor, can also be enforced by the minor. There is a rule that guardians cannot bind a minor by a contract for buying immovable property, but a contract entered into by a certificate or certified guardian of a minor appointed by the court with approval from the court for the sale of a minor can be enforced. Second aspect is being of sound mind. According to Contract Act 1872, for the purpose of entering into a contract, a person is said to be of sound mind if he is capable of understanding the contract and being able to assess its effects upon his interest. It is important to know that a person who is of an unsound mind generally, but occasionally of a sound mind can enter into a contract when he is of sound mind. In this purpose, for a lunatic person, you have to remember a contract entered into by a certified guardian of a minor appointed by the court is valid. No person can enter a contract when he is of unsound mind, even if he is so temporarily. For example, drunken person. A contract made by a person of an unsound mind is void. Third one is not disqualified from entering into a contract by any law that he is subject to. Apart from minors and people with unsound minds, there are other persons who cannot enter into a contract. That means do not have the capacity to contract. The reasons for disqualification can include political status, legal status, etc. Some persons are foreign enemy, convicts, insolvents. They are not capable to enter into a valid contract. If we will go through the examples, for example, minor, you should write by this way. Minor, A, age, son of, resident of, is a minor acting through his natural or legal guardian, name, age, son of, resident of. All these informations are for legal guardians. Next is lunatic. A, age, son of, resident of is a lunatic acting through his natural or legal guardian and manager, name, age, son of, resident of that specific legal guardian or manager appointed by the court. This is the basic difference between minor and lunatic. That is, in minor, it is not necessary to write appointed by the court, but for lunatic, you have to remember that appointed by the court is the most essential part of this, because lunatic is an unsound mind person and he is not able to understand what is actually going on. The next part is trustee. A, age, son of, resident of, trust, address, registered office, and under the law and act. As a trust, there must be a registered office, and you should mention that office address. There are few basic differences between companies and partnership. As for example, registration. A company should be compulsorily registered under the Companies Act. Its formation is very difficult, but registration of a partnership firm is not compulsory under the Partnership Act. The firm is based on the partnership deed. Its formation is very easy. Number 2, legal position. A company is a body, corporate, and a legal person having a corporate personality distinct from its member. The members are not liable for the acts of the company because a company already registered under the Companies Act. But a partnership has no legal existence distinct from its members. Partners are liable for the acts of the firm when they register themselves. Then a partnership business can get their legal personality. Therefore, a member of a company can enter into a contract with the same company, but a partner of a firm cannot enter into contract with the same partnership firm. That's why in these examples we used registered office for companies. and we used the partner's name, father's name, NID, occupation, residence address for partners. Because companies have their legal entity, they can act as a legal person, but partnership business or firm hasn't any legal entity. The partners will be liable for their acts. For next video, that is week 3, we will look at another parts of essential of a deed, that is the operative part, testatum, hibendum, reservation, and the formal part. We will also start with the condition of completion, that is attestation, and we will see the definition and what law says regarding gift. Thank you very much. That's all for week 2. If you have any questions, please feel free to ask me on consultation or you can email me. I will try to answer you as soon as possible.